Headline: Billions in climate research grants frozen. Judge demands evidence of wrongdoing. The abrupt cancellation of billions of dollars in climate research grants by the Trump administration is facing a major legal hurdle. Federal Judge Tanya Chutkan, in a Washington, D.C. District Court hearing, delivered a pointed rebuke to government lawyers, demanding concrete evidence to justify the drastic action. The judge's skepticism underscores the fragility of the administration's rationale for halting critical funding dedicated to combating climate change. The contentious legal battle centers around a staggering $7 billion in grants, initially frozen and subsequently canceled on Tuesday night by Lee Zeldin, the newly appointed EPA administrator. Zeldin, a former New York Republican congressman, oversaw the controversial decision, triggering immediate outrage and swift legal action. Climate United, a prominent organization facilitating investments in clean energy projects, filed a lawsuit seeking to unlock the frozen funds. The organization argues that the administration's actions are not only fiscally irresponsible, but also represent a blatant disregard for scientific research crucial to addressing the escalating climate crisis. The lawsuit contends that the cancellation violates established legal processes and undermines the nation's commitment to environmental protection. During Wednesday's hearing, Judge Chutkan's questioning of EPA lawyers exposed the weakness of the administration's justification. Her pointed inquiry: can you proffer any evidence that the grant was illegal or evidence of abuse or fraud or bribery, that any of that was improperly or unlawfully done, other than the fact that Mr. Zeldin doesn't like it, highlighted the lack of substantive grounds for such a sweeping cancellation. The judge's demand for concrete evidence of wrongdoing sets a high bar for the administration's defense. The administration's failure to provide compelling evidence suggests the cancellation was driven by ideological opposition to climate research rather than legitimate concerns about impropriety. This interpretation aligns with the concerns expressed by environmental advocates who view the move as a direct attack on scientific inquiry and climate action. The implications of this legal challenge extend far beyond the immediate financial impact. The cancellation sends a chilling message to researchers and scientists engaged in critical climate work, potentially hindering future research and innovation. It casts doubt on the administration's commitment to addressing the urgent threat of climate change, a commitment already questioned by many due to past actions and policy decisions. Jason Rylander, legal director at the Center for Biological Diversity's Climate Law Institute, voiced unwavering resolve in the face of this setback. He stated to The Guardian, "Come hell or high water, raging fires and deadly heat waves, Donald Trump and his cronies are bent on putting polluter profits ahead of people's lives. This move won't stand up in court. We're going to fight it every step of the way." Rylander's statement encapsulates the widespread sentiment among environmental groups and climate activists who see the cancellation as a politically motivated assault on scientific integrity. Judge Chutkan's decision to issue a restraining order pending further filings signifies a significant victory for Climate United and its allies. The order effectively prevents the administration from dispersing the funds elsewhere, preserving the possibility of their reinstatement. This temporary reprieve offers a glimmer of hope for those fighting to safeguard crucial climate research funding. The legal battle promises to be protracted and intensely scrutinized. The outcome will not only determine the fate of the $7 billion in grants, but will also set a precedent for future challenges to government actions that undermine scientific research and environmental protection. The administration's ability to provide credible evidence of wrongdoing will be crucial in determining the success or failure of its defense. The case raises broader questions about the role of science in policymaking and the government's responsibility to address the climate crisis effectively. The eyes of the nation, and indeed the world, are now upon the unfolding legal proceedings. The implications of this case extend far beyond the immediate financial ramifications, reaching into the core of environmental policy and scientific integrity. The fight for these vital climate research grants is a fight for the future.